Mochi Health is here to help you start your weight loss journey with caring, personalized support. Meet one-on-one with board-certified obesity doctors and registered dietitians who truly listen and understand your unique needs. Eligible patients can access affordable GLP-1 medications delivered right to their door each month. No insurance? No problem. Mochi Health accepts FSA and HSA, making care accessible and affordable. And with 24/7 customer service, you'll never feel alone on your path to better health. Get started with Mochi Health today. Take the free quiz at joinmochi.com and use code AUDIO40 at checkout for $40 off your first month of membership. That's joinmochi.com with promo code AUDIO40.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my repetitive co-host, Brett.
I love saying the same thing over and over again, Alice. If it's right the first time, you might as well say it again.
And, at some point, it feels like we just keep talking about Delphi, and today is not an exception.
It is not an exception. There's probably some of you out there who think, wow, they just keep trying to get everything they can out of this Delphi case. I just got to tell you, I would be fine if that case resolved itself and we never had to talk about it again. I am ready, so ready for this case to go to trial. And
now I will say,
who knows when it will.
I will say this about this case, though. A lot of our predictions haven't panned out, but it's because this is unlike any case there ever was, and I think ever will be. So part of the reason we have to talk about it so much is that in almost any other case, nothing would be happening. I mean, this is one of those cases that I keep getting surprised. And that truly, if you ask any trial lawyer what they love about what they do, being at the trial court, this is it. It's that everything's unpredictable. You can't really plan anything. And for a lot of people, that whole unpredictability sounds like a nightmare. But for trial lawyers who are a different breed of attorneys, they just really love it. And it's always fun. I will say I've never been bored at my job.
No, your job's never boring. And as we said, once a case gets to the Supreme Court of a state, you never know what's going to happen. And that was proved very true this week. Or last week.
Absolutely. Now, we were joined by our friends Alice and Bob Mata from Defense Diaries, where we talked about a lot of things. But the thing, we decided to talk about the oral argument today because there are so many interesting legal issues that were brought up in the questioning by the justices on both sides that are worth talking about. I know they've already issued an order. By the way, there's still a lot of reasoning. Their opinion still needs to come out. But it raised a lot of interesting questions. And the reason we said anything can happen at the Supreme Court is that they are not really bound by anything. Of course, there's their prior, stare decisis, their previous opinions, but they aren't bound other than by the Supreme Court, which we can talk about. They are the Supreme Law of Indiana. Now, really quick on the Supremacy Clause, Indiana Supreme Court is the supreme law of the land for all of Indiana. So not Kentucky, not Texas. You can look to Indiana Supreme Court as persuasive as another state. But if you're a lower court in Indiana, you are bound by what the Indiana Supreme Court does. The Indiana Supreme Court, we've talked about this, states are sovereigns in and of themselves. But when we all signed, the Articles of Confederation, decided to become United States of America, we did say that the U.S. Supreme Court is supreme over all of the courts, including the state Supreme Courts. So the Indiana Supreme Court is bound by the U.S. Supreme Court on certain matters. Not all the matters. And that will be very interesting to discuss as well.
Yeah, and the Supremacy Clause is something that's only being developed for the last 250 years. So, as Alice, just the long history of the United States, they're called states for a reason because initially they were thought they were going to be sort of independent entities, like United States. The U is often lowercase in older documents. And they started off, as Al said, as sort of a confederation of states, and then they became a country, and the Supreme Court didn't really do anything, and then the Supreme Court said, oh, by the way, we get to do all these things. And people are like, okay, whatever, Supreme Court. And then over the next 150 years, the Supreme Court became more and more powerful, and now there really is a hot debate about where the power of the state ends and where the power of the federal government starts. In fact, there was a case granted today. Some of you follow in Oklahoma, Richard Glossop's totally guilty, but he's trying to avoid being executed. And he has filed this appeal on the basis of the typical things you normally see, Brady violations, all that kind of stuff. And the state has more or less, the state executive at least, has more or less said, yeah, there are violations. We should vacate his, I don't know if they want to vacate the whole thing, the conviction, or just the death penalty. In any event, but the court said, nah, we don't see any reason to do that, which is a very strange situation in a state where you have like the executive and the courts are arguing with each other. So that's now gone to the United States Supreme Court. And one of the questions they're going to answer is whether or not the courts made an independent decision based solely on state law that they can't review as the United States Supreme Court. And you see that. It's really fascinating back and forth. And in fact, if you watch the oral arguments in Delphi, which we're about to get into, there was a point where one of the justices asked Richard Allen's attorneys why they did not bring an Indiana constitutional claim. And the idea was, if we're interpreting Indiana law, we have much more freedom. If we are interpreting a United States constitutional claim, then all of a sudden we are bound by what the United States Supreme Court said. So this is all very fascinating, and you saw this really play out in this case where Richard Allen is asserting his Sixth Amendment rights to be able to select his counsel, keep his counsel. It's never entirely clear exactly what portion, sort of an amorphous Sixth Amendment claim, to basically get his old counsel back, however you want to define that, whether it's continuity of counsel or right to choose counsel or right not to have counsel taken away without due process, whatever it is, he wanted them back. And that was the argument that they were considering at the Supreme Court and that we have talked about in multiple legal briefs coming up to the Supreme Court argument.
Yeah, and that's a really good point there, because the caveat with Indiana Supreme Court is supreme over state law, but not constitutional law. And so get ready with these. I've already looked into getting these Pocket Constitution giveaways. I haven't bought them yet, but we'll get them for you guys if we see you. We always talk about the amendments. Sixth Amendment is the federal constitution. So what was at issue before the Indiana Supreme Court was federal rights under the Constitution, which is really interesting because I don't think Richard Allen's attorney had a good answer I remember him pivoting at that point. But before we get there, let's back up really quick. So those of you who may be coming in with no idea what we're talking about, of course, there was oral argument before the Indiana Supreme Court, which was limited to 1 hour among the parties. So it's like 30 minutes, but the movant, whoever wants the Supreme Court to do something for them, goes first. And in this case, it was Richard Allen's attorney representing really his former attorneys. I'm saying I don't really know because this is an interesting situation where this is not a typical appeal. We've talked about, once something's final at the trial level, you can appeal it up to a higher court. This came straight from Judge Gull's decision at the trial court level to remove his former attorneys straight up to the Supreme Court. Now, how can you do that? Jumping, it seems like, other courts in between. You do that with filing for a writ of mandamus, which is an extraordinary remedy. If you listen to the oral arguments, you probably heard the word extraordinary dozens of times. You could have made a drinking game out of it. And that's because a writ is something that's incredibly rare, and it's reserved for kind of the most egregious examples where if the court doesn't step in, the Supreme Court doesn't step in, there's going to be some, massive injustice that cannot be corrected later on. And this is important because timing questions also come up during this oral argument.
Yeah, and we talked about in the run-up to it, and if you haven't listened to our legal brief on what to expect in oral arguments, I think you'll enjoy it because we talk about a lot of these issues. We talked about what we expected to see and what kind of arguments we expected to hear and what kind of questions we thought the court would ask, because all of this is about whether or not the trial court judge, when she removed Richard Allen's attorneys for gross incompetence, as she put it, and she had sort of a litany of things they had done, culminating and the negligent release of crime scene photos, including the photos of the bodies of the girls, whether or not that was a violation of the Sixth Amendment, either because of the way she did it without having a formal hearing with formal advance notice, or just as a matter of law that you can just never remove someone's lawyers. And we expected that the first thing the court would really want to talk about is their own precedent on mandamus, because this is a mandamus petition, as Alice said. It's an extraordinary remedy. And there are supposed to be a few gatekeepers that prevent you from being able to do this. And one of them is that you have no remedy after trial, that once this time passes, you're going to lose this right. We're going to talk about interlocutory appeals later. They have a similar limitation on them, that you can't bring them unless you really need to have this appeal right now. And if you were trying to read the tea leaves, and what was going to happen in this case, when the court not only didn't ask questions about that, but actually kind of poo-pooed when the state and Judge Gold is a trial court judge, and she had an attorney defending her opinion as well, sort of this notion of, is this even appropriate for mandamus? That was a really bad sign for the state and Judge Gold, because it indicated that the court did not want to allow its procedural precedents to prevent it from reaching the merits. And usually when that's the case, it means whatever the lower court decision is, it's probably not going to survive the appeal.
Yeah. And where that came up in the oral argument, if you're following along and had listened to it, is one of the justices, I can't remember which one, not the Chief Justice, kind of said, once Judge Gold's attorney said, well, this is extraordinary. This is not the appropriate remedy for something like this. And the justice kind of butts in and says, I have found 4 previous instances in which we have acted on mandamuses in this situation, which, by the way, we talked about this in a number of kind of filings to the Supreme Court, probably writs of mandamuses are going to be in the tens, if not hundreds of thousands, right, over the course of their history. 4 is a small number, but the fact that this justice went and researched all the other instances in which the court has done this indicates to you that they want this probably to be the 5th time that they exercise their right. And so I think both Brett and I, we kind of groaned when he said that. I was like, oh, well, there you go. They're going to grant some relief in this instance. What exactly, we'll get to. But I thought that was a very interesting thing, because we've told you the Supreme Court can do what they ultimately want. And one thing that I thought was an inappropriate kind of fixation was they kept asking the question, well, okay, if this is a structural error, then that means once we have the trial, whatever the trial is, you'll just have to appeal because it's a structural error, meaning you are supposed to have your other attorneys. Then we're just going to do the trial again. And they fixated on the kind of the wasted resource and how this is going to drag out everything. And there's going to be 2 trials. And Richard Allen's attorney very smartly kind of latched onto that and said, yeah, I would call this trial, if it were to be allowed to go forward, a practice run, which that in and of itself should not be a reason to exercise power when you don't have it. But you can imagine that has that weighs obviously on the court's mind in terms of judicial resources. And
that was a really bad sign for the state and for Judge Gold as well, because 2 things were evident in that questioning. Number one, the court had already decided there was an error. They had already decided there was an error, and they had already decided it was a structural error. Now, what is a structural error? So structural errors are very rare. There are only a few of them. Usually error, even constitutional error, is not structural. Think Murdaugh. We talked about this last week or week before last. I don't know. I've lost track. That they're going to have this hearing on jury tampering. And in order for Murdaugh to succeed, he has to prove prejudice. He has to prove that there was some negative effect on him. When you have a structural error, you don't have to prove prejudice. Structural error means that whatever the error is so egregious that even if it had no effect whatsoever on the actual trial, you still have to do the trial again. Famous example of this, Batson challenges. So if you strike a jury and you strike all the black people off the jury because of their race, or all the white people off the jury because of their race, that is a fundamental error that completely undermines the trial. So if you have that structural error, it doesn't matter how overwhelming the evidence is. It doesn't matter if there's no prejudice. It doesn't matter if all 12 people just looked at the evidence and they personally had no racial bias. You still have to do the trial again. And structural errors in this context, in representation, only exist, at least according to the Supreme Court, for retained counsel. So this was a really interesting thing because the Indiana Supreme Court focuses on this case that's about retained counsel, Gonzalez-Lopez, and in fact, mention it many times. And in Gonzalez-Lopez, the court absolutely says, if you deny someone their retained counsel, that is a structural error, and we're going to start this over again. Now, in Gonzalez-Lopez, they specifically point out they are talking about retained counsel, not appointed counsel. And it was really interesting to see the Indiana Supreme Court go straight to that and skip altogether whether or not there was any kind of distinction between retained counsel and appointed counsel.
Yeah. Skipping all of that, which is obviously not, there is a question because obviously the former attorney started out as appointed counsel. There were things after the fact when they were removed, they were still appointed counsel. And of course, after the fact, there was some movement about, we're pro bono, we're going to be retained. Richard Allen trying to essentially convert their status from appointed to retained after the fact of being removed by Judge Gull. I thought that was really interesting because I had prepared for a discussion about whether they were retained counsel or appointed counsel. And there was no questioning really about that when they jumped straight to the Gonzalez case. And you saw kind of the frustration with Judge Gull's attorney when he kept bringing up a U.S. Supreme Court case named Wheat. Another drinking game word that if you were listening to oral argument came up quite a bit. And in that case, he started bringing up, and this is another, you don't have to know anything about the case Wheat or anything about oral arguments, but when the Chief Justice said, all right, give me another case other than the U.S. Supreme Court case, that's a bad sign again for Judge Gull. So it's not that we can read tea leaves. It's like, we've been to enough arguments that you know where this is going. So when she said, give me another case, you may have seen that Judge Gull's attorney kind of, I think his jaw dropped open because he was like, this is the case. This is the case. And we can discuss more about why it's the case. We have discussed how it is the case. But that has happened to me before in oral argument too. But when she said that, I was like, okay, this isn't just an exercise in questioning, because oftentimes you'll have justices play devil's advocate during oral argument, asking questions, and you may think it's going horribly, and then they kind of come around at the end and they're like, okay, and then this is how the law actually is. Up to that point, I think I had some hope that maybe they were playing devil's advocate. They were testing the limits of how far their jurisprudence could be taken. But when she asked that question in all seriousness, I thought, wow, it's absolutely over. Like, they have decided how they're going to come out. And I think they had, on that front, there was a very hot bench. They asked a lot of questions of both sides, but I think they had made up their minds, all five of them, maybe not in conjunction with each other. You're allowed to talk about the cases ahead of time, by the way, but I think all of them had made up their mind before they even started oral argument.
And there were a couple things about it that were strange. It was a really interesting argument. If you watched it, you would not have been bored, but it was all over the place. There was no focus, and that's rare. Usually, the justices, they've discussed your briefs beforehand. A lot of times they don't want to show their cards, but they might say something like, this is a question I really want to get to. And they might talk about that to ensure that everybody gets all their points in. There was no focus in this argument. So there was no everybody's really trying to figure out this one thing. We've got most of it figured out, but we really want to figure out this one thing.
For example, I thought one of the things they would really want to figure out is the retained versus appointed counsel thing, which was not even, a subject for discussion.
Yeah, it wasn't at all. I mean, I really thought they're going to ask both sides tough questions. And when they finished with the first guy, I was like, well, I mean, there were some tough questions there. But then halfway through the argument for Gull in the state, it was like, this is over, because the difficult questions for him, he did not do what I expected. I did not think he would come in and basically say, you cannot remove counsel for any reason, because that's just such a loser argument. But that's what he said, and nobody pressed him on it. And no one pushed on this, easy example. So the lawyer shoots one of the witnesses. Can you remove him then? Can the client waive that? Nobody pressed on that. They just kind of let it go. And I was like, this is strange that they're doing that. And then with Judge Gold and the state council, it was like they were just hammering on their weaknesses, which were also obvious.
Yeah. And the reason, in case you're not following along, the reason that it's concerning that they did not press Richard Allen's attorney on you can't remove counsel for any reason is because when you're trying to kind of carve a middle ground and you're trying to understand and parse out your jurisprudence, you often hear in oral argument the justices pose a lot of hypotheticals of extreme facts to try and test how far their jurisprudence will go because of what we said at the beginning. This particular case isn't about this case alone, right? It's going to have precedence over all future cases in Indiana. And so it's going to pop up not in this specific situation, but lots of situations along the factual spectrum. And so when the justices, in any justices, write their opinions, they have to think about the effect on all other cases that fall on the spectrum. And they want to write it in a way that it falls within kind of a reasonable bell curve of set of facts that you can see. But there are, you can imagine, in every factual situation, there will be extremes that fall outside of the norm. And they want to carve out those extremes so that, for example, if your attorney shoots a witness, they can be removed, and that can't, they can't point to now this case and say, nope, see what the Supreme Court did. And so when they didn't try to engage in that intellectual parsing of what that right was, it meant that they knew exactly what they were going to do here. And it wasn't going to be a, kind of detailed, intricate explanation of when you can remove counsel and why this situation you get to remove counsel.
And I'll say this, maybe they will. We don't actually know because at the conclusion of this, they issued an order. We're going to talk about that more in a bit. But they haven't issued the opinion yet. We don't actually know what the basis is for their opinion. But Alice is right. I mean, there aren't that many. There was a reason that Richard Allen's people were citing 1964 California cases. There's not a lot of precedent out there. So this is a real opportunity for the Indiana Supreme Court going forward to lay out for judges and for counsel what exactly the boundaries are here. When can you be removed? In Indiana, maybe it's not going to matter whether you're appointed or retained. Maybe going forward, that's great for the United States Supreme Court. We don't care. We're going to do it differently here. Maybe that's what they're going to say. Or maybe it was about a hearing. Maybe it's, look, this is just too important a right, even if you have a record, even if you can figure out the reasons, even if it would be mostly pro forma, still need to have the hearing. You just need to have a hearing if you're going to remove counsel. You need to establish that record. Maybe that's what they were thinking, but they didn't press anybody on that. They weren't pressing Richard Allen's counsel on if she'd had a hearing and she had laid out the facts. Would it have been enough? If not, what would be enough? What are the circumstances in which a judge should be able to remove a counsel? This is usually the kind of stuff you're going to get because they're trying to figure out what the boundaries are. To give you an example, they did do that with the other side. One justice asked, could you do this with the prosecutor? Which the answer is yes. Prosecutors are removed all the time. Now, for whatever reason, when counsel was asked that question, they weren't ready for it and didn't give the answer, which is, yes, of course you can. If the prosecutor is violating orders and doing all this stuff, the judge has the authority to remove them. But they weren't ready for that. But that's the kind of question when you're trying to see what those boundaries are going to be. And I'll just say to Alice's point about wheat, I've had that happen in a case where it was about the record. And I'd anticipated this question. That somebody was going to ask me, where in the record does it say X? And so I had found it, and I had written it out on my little sheet, and I was ready. And I got asked, and I was like, yes, you're walking right into my trap, Judge. And so I cited, I was like, well, it's on page 137, line 27. It says X, Y, and Z. And the judge said, I kid you not. Well, where else does it say it? And I was like, well, what am I supposed to say to that, right?
So I mean, this is what wheat was about, right? So it's wheat versus United States, and the Supreme Court said that a trial judge has the discretion to disqualify defense counsel even over the defendant's objection if a serious possibility for a conflict of interest exists. And, I mean, really is on point. like literally, that's the facts here.
And just,
I don't know what else to say.
Another thing that happened that kind of blew my mind, and there were times where I was like, am I the only person who cares about Richard Allen watching this? So the court starts talking about waiving ineffective assistance of counsel. And Richard Allen's attorney is like, oh yeah, he totally can do that. And he did it in this letter. And I'm thinking, so what you're saying is if your counsel is ineffective, that same counsel can tell you, you should waive my ineffectiveness. I'm going to write out a letter for you saying that you waive my ineffectiveness. You're going to sign it, and then I'm going to use that later on to say you waived the ineffective assistance of counsel that I provided you before. How does that...
see any conflict of interest there?
Yeah.
Like at all? Especially when this is the same client that you previously said in filings was not mentally competent to be doing anything and has lost their mind. But somehow they're able to waive a very substantive right here, have it in writing that you helped write. And then it's what? Is it a get out of jail free card for like ever? So like, is it only up until this point? What about all the things that you're doing? Is it a continuing action? What if you get back on the case and you continue to do the types of things that you did previously, but they're new instances? Are those waived? Are they not waived? I mean, this is waiving ineffective assistance of counsel is a huge, huge thing. Everyone holds it in their back pocket because no matter what, no matter how competent your counsel is, if you lose, you want that in your back pocket to say, super ineffective. You know he's ineffective because I lost and I'm supposed to be acquitted, right? I mean, we have seen ineffective assistance of counsel claims left and right all the time. Very few, most of them are baseless. And it's because it's just another kind of tactic to basically try and get a new trial, try and basically get a conviction overturned. And I don't know if they really discuss all the implications of that with their client, who was not their client anymore. So that's also very interesting. He was represented at some point by the new counsel that had been appointed by Judge Gull, and how that would play out. But I have never, have you ever had a case where you guys had waiver of ineffective assistance of counsel? I've never seen it. And the reason I mean, just to show you how uncommon it is and how serious it is. Oftentimes when you reach a plea agreement with the defendant, right? Most cases we know 90+% of cases plea out rather than go to trial because of a number of reasons we've talked about in other legal briefs episodes. It's just the reality. Most cases do not go to trial. And so in these like 90% plus cases where you have plea deals, you have, things that the defendant is getting in exchange for not having to go to trial, not wasting their resources, accepting responsibility. Sometimes they do, sometimes they don't. But one of the things that they almost always bargain for is that they waive their right to appeal. You can imagine why, right? There's finality for both sides. You don't waste additional resources. Like if you're just going to appeal, let's just go to trial. And so you waive your right to appeal your conviction once you say, I plead guilty pursuant to this plea agreement. But in that appeal waiver, there is always a carve out for two things: prosecutorial misconduct and ineffective assistance of counsel, because those are kind of outside of the purview of this case. And they are so fundamentally unfair, right? Like it wouldn't be fair if I, as the prosecutor, like just lied up and down and you found out later, but I got you to waive your appeal rights. No, there's a carve out for that. And likewise on the defendant's counsel side.
And remember, what is this whole case about? It's about the Sixth Amendment. What is the core right at the heart of the Sixth Amendment? Effective representation of counsel. So we're saying here he can waive his effective representation of counsel, the core right, because of his ancillary rights for continuity of counsel, because he likes these guys. And we're going to let him do that, even though he doesn't really know what he's giving up. We have waiver. You can waive certain things like conflicts, because conflicts are pretty easy, right? I mean, it's easy for a judge to explain to you why there's a conflict, and you can make a rational decision. Does it bother me that I'm being represented by a firm that's suing this company, and their corporate side is representing that company in a merger? So do I feel comfortable with their litigation side representing me with that corporate side, or is that too much and I want somebody who has nothing to do with them? That's something that you, just as a layperson, can understand. Ineffective assistance of counsel, you can't. I don't understand it. I'm a lawyer. No one understands it. It's really complicated. And the idea that Richard Allen could just, in the middle of all this, just waive his rights to effective representation, to me, is just, I don't know. I was amazed that the court seemed so ready to accept that. And the Chief Justice kept going back to self-representation and saying, well, if you can represent yourself, why can't you waive effective representation? And I was like yelling at the guy, point out that you can't just walk in and say, I represent myself. There's a whole process precisely because of this. Yes, There's a Feretta colloquy. And you have to show that your waiver is knowing and voluntary. And when it's knowing, that doesn't just mean you know you're doing. It means you have experience with the courts. You understand the way the system works. Like there's like a 15-point thing you have to get through. And if you get to the end of it, the court can say, no, I don't think this is knowing and involuntary. Sorry, you're going to have a lawyer. The court can deny that from you because we've decided, even though you have a right to represent yourself, because of all the complexities here, it's not unlimited. And I just didn't understand why nobody mentioned that.
It didn't even come up at all. I mean, not even grappling with the fact that that was not like an unfettered right, that the courts have an interest. And we've said this all along. Some of you may be thinking, why should we care? If this guy, he doesn't know how to represent himself, let him represent himself. It's going to be terrible. He's going to be convicted of murder. No. The reason you care is because the court has an interest in preserving the justice system for everyone. So the court is in a position to be looking out for the defendant as well as that the prosecution is held up to their standards. And that's where kind of the discretionary right of the judge is coming in, which this is not something we heard at oral argument, but that is at the heart of why Judge Gull and trial courts have the discretion to do things like remove counsel when there's a serious possibility of conflict of interest or perhaps repeated gross negligence, as she, saw in this case. I don't say found because there wasn't actually a record made, which is a problem. But that's why that discretion exists, because trial judges are living this, living, breathing thing that is the trial level. And they have an interest in making sure they're the gatekeepers of justice. That's why there's the Feretta hearing before the defendant can represent themselves. That's why there's an entire plea colloquy. Even if the person comes in and is like, yep, ready to plead guilty, you don't get to just walk in and say guilty. It is a hearing, and there are specific questions called the plea colloquy that you have to go through, where the judge, even if you've pled guilty to other things, even if you're like, I already read it, I know, my attorney showed it to me, I signed it, look, I wrote it down. Even if all of those things are true, it has to be said out loud by the judge to you. Not by the attorney to you, the judge to you, because the judge has to be convinced of your understanding of what you have waived in exchange for what you're about to do, whether it be to represent yourself or to plead guilty in a case.
And it was interesting, at one point, one of the judges was like, is this really about insubordination or is it about ineffectiveness? And it's about both. And I think that the biggest issue here, and one that several of the justices pointed to, is the record. I think at the end of the day, and we're going to see when the opinion comes out, we'll see what they say. But I really think they hated this record. It was too amorphous. They're having to make this decision based on what was said in chambers and emails and telephone calls and everything else. I just think they didn't like that. I think they really wanted Gull to have a hearing. At one point, the Chief Justice said something along the lines of, to one of the state people, can't we just send this back and if she can have a hearing and we can do this over again, essentially. Now, I don't know that would necessarily be the best course of action for her to do, but I think Judge Gull, it was one of those, what is it, penny wise and pound foolish? She saved an afternoon of a hearing and wasted 3 months of time. If they just had the hearing, and look, and I think part of it was she didn't want to embarrass these people in front of everybody, and I think a lot of it was to save time and effort, and it ended up wasting a ton of time, and I think that was a huge mistake. And I'll say this was a split decision, it appears, based on the order. So they unanimously denied the motion to remove Judge Gull and the motion for the speedy trial. Now, the reason they did those is because whatever mandamus means in Indiana, it doesn't mean that you can get a speedy trial order when you've never asked for a speedy trial. That's number one. And number two, it doesn't mean you can remove a judge when you've never had that filing decided at the lower court. Because the judge could say, sure, yeah, you're right, I'm going to recuse. Or she could deny it and give all sorts of reasons. But what they did do is they reached a majority opinion restoring Richard Allen's former counsel, Baldwin and Rosie, to represent him. We don't know what the split was. We don't know what the reasoning is. We don't know why the people dissented that did. It could be that all 5 kind of thought they should be restored, but 3 think there's an absolute right to your counsel, and 2 of them don't think there's an absolute right, but think there should have been a hearing. Maybe that's it. Or it could be that a couple of them, or one of them, thinks that, no, you can remove them for any reason, and the rest of them don't. We just don't know. We're going to see.
We just don't know.
It's speculation at this point.
I mean, but one thing to note that, the hearing was an hour. It ended, around noon? The order came out just a couple hours later, which is incredibly, incredibly fast. And it said an opinion would follow. But it happened on Thursday. So as of Thursday, really, but I think the opinion came out later in the day. As of Friday, Rosie and Baldwin were back on the case in front of Judge Gull. And the case was now back before the trial court. And we had kind of thought, well, what's going to happen? Because effectively, the case is right back to where it was before. It is ongoing. The order was clear that this doesn't stay anything. The trial court can continue to move along because there are still pending charges against Richard Allen, and there's a trial date set for later this year. And, well, Judge Gull did not waste any time. There was movement in the case today. She did a number of things. One thing to note that didn't happen, despite asking the Supreme Court to set a trial date within 70 days and never having filed a speedy trial request at the lower court, they came back to the trial court and still haven't filed a speedy trial request. So any of you thinking, why didn't the judge grant their request for speedy trial? It's because they never filed it yet. They can file at any time, but they have not filed it. And the other kind of big thing she did was she denied the Franks motion. Remember that 100-plus page filing that espoused a pretty big theory that involved some sort of cult? That has been denied. That's not surprising, because that is a Franks motion, which we explained is attacking the four corners of the search warrant to search Richard Allen's house. Whereas the filing really didn't touch upon the reasons that affidavit should be challenged. It was about their theory of the case, and we had, theories ourselves as to why they put all of this, completely unrelated information into a Franks motion. But as a Franks motion with respect to challenging the affidavit, the search warrant, it had no legs. So there was no hearing. She denied it. Doesn't mean they can't file another motion to suppress or something along those lines, which I think they probably will at some point. But this is just another one of the many motions before them. And, interesting to note, did this happen at argument, or is it all the commentary afterwards? People have said, oh, it takes the judge, so much time has been wasted, what have you. And one thing that Judge Gull did today was she moved the case along. Certainly she did. We are still kind of in a little bit of a limbo land in terms of what that opinion is going to say as to what the court may want her to do, because it is a mandamus, or not do. It's not clear, but she's like, well, you said it's not stayed, and my job is to move this case along, and that's what she did today.
I mean, look, I think the Supreme Court's decision, whatever the opinion is almost for other cases. It's like we were saying, this is about more than just this case. I think I would be surprised, even if, I might not be that surprised, but even if the Supreme Court said the real problem here is you didn't have a hearing, I would be a little surprised if Gull went ahead and did the hearing and all that and removed them again. I know a lot of people want that to happen. Personally, I think that would be a mistake. I think that ship has sailed. I think she messed up in the beginning. She didn't have the hearing when she should. We need to move forward. If they mess up again, they'll have the hearing.
Those will be new grounds.
Exactly. And recount all the previous reasons as well and remove them
because the Supreme Court has made clear what they think about her list. Right? Even though she didn't make an official record, we have, the unofficial transcript or the transcript of the recording. So we know what actually happened, but it wasn't done on the record. So clearly the Supreme Court already knows her list of reasons, and it was discussed if that was enough. And you got to read the tea leaves. They're like, nope, don't think it's enough.
And the Supreme Court made clear that they wanted this case to move forward. They wanted to get it back on track. And you can't have a trial if you have pending motions. Speedy trial, you can move for a speedy trial all you want. If you have pending motions by the defense in most jurisdictions, and my understanding is Indiana is one of them, it doesn't actually mean anything until those pending motions are removed. The clock is not running while defense is filing motions. That would be unfair to the prosecution, the state, and then the judge and everybody else. So in order to move this forward, you really need to go ahead and get rid of this Franks motion. And the thing, a lot of people I think are upset because Judge Gull didn't have a hearing before she removed these guys, and now she's not having a hearing on the Franks motion. But I think it's really, really important for people to remember. The reason we call it a Franks motion is because it is governed by a Supreme Court case that laid out when you can do this. It is extreme to challenge the face of a search warrant in the way that they're doing it. Ordinarily, if you receive a search warrant, you get to search. That's the presumption. You only get to have a hearing if you meet this high standard as the defense, if you put forward this sort of prima facie case. We talked about this a lot in past legal briefs. So the fact that they're not going to have a hearing for the Franks motion is absolutely normal. I would say we have Franks motions filed in our office, not frequently, but it's not so rare that we've never seen it. And of the times we've seen it, I think we've had one hearing. And frankly, we shouldn't have had that. The judge messed up having that hearing, in my opinion, and we won after the hearing. So they're very rare to have. It takes a high bar. No judge, I don't care if Judge Gold had recused and some other judge had come on, they would not have had a hearing for this Franks motion. Not based on that Franks motion, which wasn't even really a Franks motion. The other things that she denied, there was a request for a hearing on the ballistics information. Basically, the defense wanted to have this. They basically want to put ballistics on trial, I think, is essentially what they wanted to do. And I think Judge Gold denied that because there will be an opportunity to challenge the scientific validity of ballistics evidence during a Daubert hearing, which is what I think.
I wanted you to say Daubert.
There are two. I always forget what the other one is. Like a minority of states use the other one, and I always forget what it is. But Daubert is the majority.
I've only ever done Daubert.
And... Right. And that's an opportunity
Daubert is a challenge to the expert.
Exactly.
Which is battle of the experts. And as it rightfully should be. So that is going to be fascinating. That really is an interesting issue. I can't wait to see what the experts have to say about it. I'm not an expert in ballistics, so I don't know. I've talked to all of my law enforcement friends, whenever we talk about the ballistics in this case, like text me like crazy. So we actually, we should actually have some of them on. Because I have a couple NIBIN.
That's what I want.
Folks.
I want a NIBIN person.
Okay.
If you I have a NIBIN person.
I have a NIBIN person. We'll have him on to talk about ballistics because he was explaining things to me and I could not quite wrap my head around it, but it'll be a very good primer for what will actually be interesting in this case. Because look, guys, this case is interesting, but right now it's been interesting for all the wrong reasons. This is interesting because of the ballistics issue, which I think is going to be one of those kind of issues of first impression, in that this is not a very I've never used this type of ballistics in my cases. I'll put it that way. It's kind of a new type of way of looking at how to use ballistics. Obviously, this is a horrific fact pattern, this case. There are so many things that are interesting to discuss about this case in terms of the law and how it will play out during the course of a trial. But again, the reason we've been frustrated is the things we've been discussing, not interesting. It is detracting from the victims, and it's detracting also from Richard Allen's rights here. And I do hope that we can get back on track, put this all behind us, and move along with the case for the sake of Richard Allen as well as the victims, the girls in this case.
Yeah, so I hope you guys enjoyed the Supreme Court argument. They're rare, I guess, but it seems like all the big cases have them right now. We've got this one going on in this case. We got one in West Memphis 3, which we talked about a long time ago, that whole habeas issue. And I was looking at their briefs, which they filed a while ago, and I was curious that the movement, Damien Eccles, did not ask for oral argument, which I always think is surprising. I always think that's a sign of weakness when you don't ask for oral argument, but we'll see. There's a lot of press attention on that as well, so will the state of Arkansas expand its habeas to include people who aren't in custody, which... At this point, who knows? I'm sort of like, what is the law? What is
brand
law?
New world?
What is law?
What law is as I feel it.
Yes, exactly.
Everything's a structural error. You get a structural error. You get a structural error.
And then, of course, Adnan Syed is still pending as well.
It is.
Which I assume that will go his way as well. So, whatever.
Yeah. Maybe 2023, all the interesting legal things were happening. Maybe 2024 is the year that law breaks down.
Maybe it is. Maybe it is. I guess we'll see. We'll see what happens in all those. And then who knows? Murdaugh. He could end up in front of the South Carolina Supreme Court if his evidentiary hearing doesn't go right. In fact, he will. He definitely will.
Yeah,
if
he definitely will bring that to the Supreme Court. Well, we have a lot of lawing ahead of us, which is fun. I guess gives us topics for legal briefs. Exactly. All this content. Well, Brett, I'm impressed we did this in kind of within the hour. But before we sign off, do you have anything else to say right this moment about what has happened so far?
Oh, I have so much more to say, Alice, but it would keep us here all night. Do you want to answer questions?
I definitely do.
Okay. So these are Legal Briefs questions, as we've noted before.
All right.
If you leave a 5-star review for Legal Briefs, you go right to the head of the line for questions.
Because there's not a long line.
Oh, man. Okay, this is from CF15403. And they want to know, what was the best day of 2023 for each of you? And what is something new you hope to accomplish in 2024 now that you are award winners and have a well-deserved gigantic fan base?
Oh, that was so nice. I'm like blushing. I don't think that's true, but thanks. Okay, you go first. Best day of 2023.
It's definitely meeting Lily Ann at CrimeCon. That was my best day. That was amazing. Best day of 2023. I don't know. I mean, it would be something with my kids. I mean, CrimeCon was pretty awesome because I've got the video of my daughter watching me on television getting the award, and I've got the going to Disney World and her looking at me like she couldn't love me more. So I think CrimeCon weekend might actually be my best day. I don't know. It was definitely up there. I have a feeling I know what yours is. You're gonna cheat, but that's okay.
I mean, it'd be really bad mother moment if I didn't say the day I met Brittany. But I'll say a close second has been a continuing one. It's all stemmed from that beautiful day in 2023, was the amount of confusion across the interwebs and also in my personal circle as to whether my daughter's name is Brittany.
It's true, and that confusion
endless fodder
continues.
for fun.
Yeah, and it continues. What's
Actually,
our plans
so
for next year or this year? I don't know.
Our plans for this year.
What are we trying to accomplish?
You know, the bad thing, they're always like, set goals. That's how you'll make them. We never set any goals ever. We're like the least intentional podcasters.
It's totally true.
We're really bad at this. Okay, so maybe not specifically with the podcast, but like your life, I guess.
I don't know. I don't know. I mean,
with the podcast. Okay, my goal for 2024 is to, like, straight up Indiana Jones style, steal the award back from Brett and not have him notice. And you guys will have a fake one in the back that you get to keep watching.
Here it is, right there. You see it? Right over my shoulder.
Yeah, I can see it every single time. You don't think I know that you position your camera so I can see what I don't have every time?
See, that's my goal. My goal is we got to win another award so I can give one to Alice. That's the problem with having two hosts and only one award. Next, I could take like a saw and cut it in half or something. But
that is very Solomonic.
it would be. There you go. I don't know. I don't have.
And then I would be the real. I'd be the real podcast. I was like, don't hurt my podcast award. You can have it. And they're like, she is the true winner of the award.
I feel like my goals are always very low. Like live through the end of the year and keep my children fed, not get fired. You know, not have the podcast just fall apart. Not have you quit on me. I don't know. Like I have very low goals, so I feel like I'm always accomplishing.
I know
things,
our
right?
goals are always like, can we record twice this week?
Yeah, exactly. Can we actually keep putting out an episode every week? My goal is to finish the West Memphis 3 outline. That's my goal. So then we can.
You really
we can
just want
cover
to
that
tease
case.
people, huh? You really want to tease people, huh?
I just want to tease them as much as I can. Okay, let's do one more. Do you have another goal?
More.
Do you have another goal?
No, I don't like. I like to keep things close to the vest. You just gave away the whole kit and caboodle.
I'm sorry. Oops. Okay, let's see. This one's funny. This is from Abe Bruce. Have either of you ever been held in contempt of court? If so, what was your punishment and what were you held in contempt for? I can't imagine being held in contempt. That's the thing. I can't imagine acting the way these lawyers act. I would just die.
No.
I would melt into the floor if I did some of the stuff they did.
I mean, literally, no, we get yelled at all the time in court, but not because we've done something wrong. It's because they disagree with our position. But sometimes it gets kind of personal and they're like, lawyer, you don't know what you're talking about. I turn beet red and want to sink into the floor and never lift my head again when the judge asks me about a case and he's like, well, how happened in that case? And I can't recall it. I mean, that's not even close to being unethical. I'm like, it's at the tip of my tongue. There are 15 cases at the top of my mind and I can't recall the facts right now. No, I've never been held in contempt. If I were, I would probably just quit the law and take up knitting as a lifetime hobby.
I just can't even imagine. It would be so terrible. They have a bonus question as well. So, no, we've never been held in contempt. Come on. That's crazy.
No.
My 14-year-old...
And by the way, it is very rare to be held in contempt. Like, it is not something that's dealt left and right that you just get slapped with. It's very rare to have like a bar complaint against you too. So these aren't just like willy-nilly people get to leave 1-star reviews. These 1-star reviews, we got so many of them. That doesn't happen in your legal life. People can dislike you, but you do not get disciplinary action against you on the regular. If you do, you're disbarred.
Right. Especially when you're a prosecutor. You know, it's one thing if you're a defense lawyer, and you'd be amazed what defense lawyers get away with. And I'm not being critical of defense lawyers. It's just, you know, we get these little magazines every month, the bar magazine they send out, and it always has the disciplinary stuff in the back.
It's just there for everyone to see.
For everyone to see. And it's like, lawyer such and such from this town did this thing, and this is the punishment, which would be so embarrassing. But you'd be shocked at the stuff people do, and it'll be like 1 month suspension. Like... It's just blows your mind. Blows your mind. We would never get away with some of that stuff, but it's okay. Okay. Bonus question from A. Bruce. My 14-year-old loves to argue. I mean, runs in her blood, my husband's side, of course. She will say things such as, make it make sense to me. It's not an opinion, it's the facts, and I'm sorry you don't agree. She is a stickler for rules and honesty. For years, we have made jokes that she should become a lawyer. The problem is she is not a strong student. She does well in English, but struggles in math. Well, that's not a problem.
That's great for a lawyer.
What advice can you give as she, let's see, well, the thing ran out, but I think basically she really wants to be a lawyer. What advice can we give her to help her attain that goal as she prepares to enter high school next year?
I think she'll be okay if she hasn't even entered high school yet. There's time to prepare for law school. First of all, one thing, we all have gotten that joke before where it's like, you must have been argumentative as a child, or like, because you argue a lot, you should be a lawyer. There is some truth to that. You have to have the fight in you to want to be a litigator. Not all lawyers love the fight. Mr. Alice does not love the fight, right? So they're different personalities. So that is a personality of a litigator. But the thing I think is the most important is just liking to fight or just liking to debate and be right is not what actually makes a good lawyer. It's knowing, being well-read, and understanding the reasons that underlie why your reasoning wins the day, right? It's not just having the loudest voice and being able to talk over people. So it sounds like she actually has, what, as a 14-year-old, and trust me, I have one of those kids, it sounds like she likes to be argumentative, but I would say the questions that you say she asks, she has a real curiosity, and that's awesome. So it's hard when you're in like middle school, high school, because you have to take these 7 classes or whatever. What if you really don't like physics, but you have to take it? Well, as she begins to expand and go on to, college, which she has to go to before going to law school in the United States, is maybe choose like a liberal arts education where it allows you to really pursue the things that you love. She may actually love philosophy, but really dislike physics and chemistry. Because she has that thirst for knowledge, I think that she would actually end up excelling academically in the things that she likes. She just happens to be in kind of the stodgy way that we have structured education right now.
So I went to law school, and when I was in college, I was a philosophy and a history major. And my weakness was always math and science. And I took my required science that I took was Introduction to Biology for non-majors, which it was like me and the football team.
That's a great title.
And that's how I got through the science portion. And then I did the philosophy and the history stuff. I was always better at the reading, like the SAT and everything. I'd kill I'd get perfect scores on all the reading, comprehension, all that stuff. And then the math was always a struggle for me. I just was never good at it. And fortunately, as a lawyer, that doesn't matter at all. So unless you're going to be like a patent attorney, you probably don't have to worry that much about math. So I would say, look, I think everybody should focus on their strengths. So she should really lean in to her strengths. Don't worry so much about the weaknesses. Work on them, but don't let them bring you down. Don't let them hold you back. And really sort of lean into the things she's good at and build on that. So, nobody asked a Supreme Court justice in their confirmation hearing to, I don't know, define the limit of some equation. Alice would be able to give a better example than that. But anyways, this is so much fun. Let's do another one. Okay.
Wait, really quick before we move on, because I've been meaning to do this on multiple lives, but we've
Okay.
had such so many lives. I want to say a really quick thank you, which is tied to the very first question, the best day of 2023. Okay, Leslie learned to crochet and crocheted a blanket for baby Brittany and sent it to me while she had her own newborn baby. And I've been meaning to thank her on one of these. And it literally brought tears to my eyes because we hope you guys know we love you guys. You're not just this faceless chat or people who listen. When you write to us, when you share your life with us, when you share, hurts in your life, joys in your life, and you do things like reach out when the biggest day of my 2023 and really one of the biggest days of my life, having a baby, those are not easy things. To have you guys there was incredible. Truly incredible. That cannot be overstated. So a really special thank you to Leslie, and also thank you, all of you, for just being a real family to us and not just listeners.
We say this all the time.
I never expected this.
It's totally true. This community is amazing. It really is amazing. It's the best part. And so it keeps us going. Because I just got to tell you, there are downsides to doing this, but the community is not one. And you guys are awesome, and y'all have been so great to us. So just know the reason we keep doing this is because of you. So thank you for doing that. I'm going to need a blanket too. Anyway. Okay.
She's working on it. It takes a lot of time.
You have both mentioned, this is from Penny the Baker. Penny the Baker says, you have both mentioned that you've worked in different capacities of law, federal, state, private. Which one was your favorite and why?
I've been blessed with great jobs. I really have. I've worked a lot of different jobs within the government and also in the private sector. And I'm just really lucky that I have had good jobs. Not everyone has that experience. And I think the reason I've loved my jobs is I've been able to work with great people like Brett. We got to work in multiple positions together when I was still in the government. But nothing quite beats getting to work as a prosecutor. I know I'm not just saying that because this is our podcast. There's just really something special about getting to fight for something every single day that you believe has a positive impact much broader than your immediate circle, your immediate town. If you can deter one, woman beater here, it does have effects and ramifications across the country when that guy gets hit with a really, really devastating sentence because of the cruelty that he's exhibited. And it sends a message to victims all over that somebody cares, that you're not small, that someone as big as the big bad government cares about you and will spend their, nights and weekends working, far more than really I've ever worked in the private sector to make sure that you have justice. And what I loved about that, which you don't get to do really in any other position, we've talked about this a lot. I had the ability to turn down cases. You don't get to do that in anything in the law, except kind of as a prosecutor. When you don't believe that the evidence is there for your case, you recommend to not pursue the case. That is a privilege to get to do something like that. And we take that privilege very, very highly. Again, like in the private sector, your clients are who they are, and you make the best arguments you have, even if they're bad, not bad, but losing arguments. And you don't have to do that as a prosecutor, which is just a real privilege.
Yeah, I agree with Alice, and there's a reason I chose to commit to public service at a pretty early stage. And nothing wrong with being a lawyer in private practice, as Alice is now. And there's a lot to be said for that, and you can do a lot of interesting things. But I think for me, when I was Deputy Solicitor General, and one of my really good friends was Solicitor General for the state, and it was just the two of us. And that was so much fun, and it was so great because you're doing what Alice was talking about, stuff that really matters, that really has an impact, and you're doing it at a really high level, arguing in the highest courts, filing things in the Supreme Court, winning cases in the Supreme Court. It was just an incredible experience, and some really, really tough cases too. That's where I've mentioned before, I've done a lot of death penalty work in the past, and that's where I did a lot of that. And in those cases, seeing the victims and the terrible things that happen to them and feeling like you're sort of upholding this ultimate justice in their cases, and knowing how a lot of the times the victims' families felt, and seeing them wanting to get justice for their loved ones, and you're fighting for that and fighting for it in front of appeals courts and the Supreme Court and everything else. Just an incredible job. Love that job. But I would say a close second is my current job. I really like doing it for all the reasons Alice said. And I really think you can make a difference. And I think it's really important to have thoughtful people as prosecutors because, we have to wear that white hat. Defense attorneys like to talk about all the time how they defend the Constitution, and that's great. And we love defense attorneys. We got a lot of defense attorneys who are friends. We take an oath to defend the Constitution. The Constitution is our ultimate client. A defense attorney represents their client. We're supposed to represent justice. That's supposed to be what we're doing. And that means doing the right thing regardless of what that means, whether it means winning a case or prosecuting a person. I mean, you have that huge responsibility, and it's something I take very seriously and am proud and privileged and happy to be able to do. All right. Well, that's all I got, Alice. I've talked all I can.
Those were really good questions. I just have to say, these legal briefs questions have been really, really good so far. So, leave that 5-star review, ask a question. We'd love to answer it. And thank you guys for listening to Legal Briefs, to the prosecutors. If anything, kind of on the New Year's, what do we expect is just, I never could have imagined where we are right now, this life, kind of this bonus community 5 years ago in my life. And you guys have changed my life. And we're not going away anytime soon. So thanks for listening. And as always, we love to hear from you guys. We love talking about things on Legal Briefs that you want to hear about. So email us at prosecutorspod@gmail.com if you have any ideas or thoughts about today's episode. Also reach out to Twitter, Instagram, Facebook at prosecutorspod. We read those messages and we love them. And of course, if you want to have great intelligent discussion, join our fan-run Facebook group, The Gallery. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Well, have fun tomorrow.
It should be fun.
No pressure. Don't mess it up.
I know. That's what I said. I'm kind of nervous
every single one of the
about
true
it.
bills, everything that's indicted under this grand jury is like they were not properly impaneled, so you have to as if none of them ab initio, all of them are.
See, I was afraid they would no bill everything because I'd scared them too much or something. So, yeah, Joe, there's voir dire. You got to figure out who's going to do it.
Sure
And you do it for a whole year, so this is
it's a commitment.
it's a commitment.
I never.